Hi everyone, and thank you so much for joining me. If you are in the process of selling your home or looking to sell one of your properties, this is an absolutely essential video for you to listen to. I'm Christina with Equity Union Real Estate, and my guest today is Michelle Seltzer of Seltzer Legal Group. Michelle is a real estate litigator and one of my most trusted advisors when it comes to helping my clients through their real estate transactions, especially on such an important matter such as disclosures. So thank you so much for joining me today. I am super excited to have you because I feel like this talk was a long time coming.
First of all, thank you so much for having me as a guest. And second of all, it's been a long time coming. We've been talking about doing something like this to share this information with the public for a really long time, so I'm glad we're finally getting to.
Yes, me too. So if I could have just gone back in time and recorded all of the various conversations that we've had over the years about the cases that you're working on and some of my clients' transactions and how we've brainstormed together, I think it's just gold. So, which is why we're here today. So, specifically on the topic of seller disclosures, I think this is such a fundamental piece of information to talk about. Like, if this was a college course for sellers, I would just call it How Not to Get Screwed in Your Real Estate Transaction 101, because knowing what to disclose, when to disclose, and how to disclose can really make such a difference in the real estate transaction in terms of liability and keeping yourself safe and protected from potentially getting sued. Now, we can't control if somebody is going to be suing another party during a real estate transaction, but what we can control, I feel, is how diligent we are, we as brokers and sellers, in what we are disclosing.
I think that's such a great point. One of the things that always comes to mind is that, especially with a first-time home buyer, they really don't have great expectations or realistic expectations of what they're getting. And somewhere in their mind, they think of it like buying a car that's gone through like a inspection and you're buying it through a certified reseller.
Right.
And that's just not how these transactions work, especially when you're in the Los Angeles area. A lot of the homes are quite a bit older. You're not buying a home that's new. You're not buying a home that has new plumbing. And there may be things that are wrong with it that the seller had no idea about, or that just didn't bother them as much as it may bother a buyer. And I find that particularly first-time buyers are more sensitive to it because they weren't expecting to have any further repair costs once they bought the home. And it is often the case that little things pop up that you need to take care of that were deferred and not handled by the seller. But that doesn't mean that the disclosures were bad. So it makes it a whole dialogue throughout the process of selling, during escrow, and even before, between the seller's representatives and the buyers as to what they do know. And it's a balancing between not wanting to over disclose, not wanting to make it sound like it's a sinking ship from a sales standpoint, and also wanting to paint a realistic and accurate representation of what is going on with this property.
I love that you brought up about how it's part of the ongoing process, not just during escrow, but also even before. So personally, when I'm advising my clients, my seller clients, when we take the listing, that's when we go through the disclosures. You know, I can't tell you how many times I've been through an escrow process representing the buyer, and we're tapping our feet waiting for the seller disclosures, and I hear from the listing agent, oh, the disclosures are being worked on. In my head, I'm thinking, shouldn't this have been worked on from the very beginning? It's so important as the agent to know the ins and outs and the good and the bad of your client's home, the product that you're selling, what you are presenting to the buyer. So when I take a listing, I go through the main disclosures, which are the transfer disclosure statement, the TDS, and the seller property questionnaire, the SPQ, which are total 7 pages, a bunch of questions, which all start, are you the seller aware of? So let's talk about that verbiage for a minute, because sellers oftentimes see these forms and they're like, oh wow, these are a lot of questions. I don't know, does the home have this problem? Does the home not have this issue? I've lived here for 40 years. I don't remember if I replaced this particular item or made this kind of a repair. So let's talk from a liability perspective, since you're the attorney and you litigate these kinds of cases. What do you find to be the most common issue when a case comes to you? And let's say it's a buyer that says, I purchased this home and I read through the disclosures and I did my inspections and I have a feeling that the seller hid something from me, or the seller didn't disclose this issue with the plumbing, for example. How do you, as the buyer's attorney, look at this and advise them as to whether or not they have a case against the seller?
So let's first talk about what the standards are that could create liability for a seller, and I'm speaking about California transactions.
Right.
And in other states, they may have other requirements. And in California, we really hold people to a standard of, if the seller knows about something that could materially affect the value of the property, they have a duty to disclose that. Now, that is such a broad thing and could encompass a lot of scenarios and conditions of a property. Remember, if you're selling a 40-year-old property, again, no one is expecting it to be in completely untouched, pristine condition. But one of the things that the seller and the agent can be doing to protect the seller is, like you mentioned, at the time of the listing process and even before, sellers should be gathering their records. Some of this comes down to great record keeping, including being able to say, instead of me listing for you all the work that we did, we have records of the work. Here are the invoices from the contractors that we used. Here's the receipts for the items that were installed, new water heaters or other devices. Here are the permits that we had, and keep a really good file. It's so much easier now electronically, because what they're going to be asking you about is, what did you know happened to this property while you owned it, and what work did you do to it? So by just having those records, that answers about 80% of that. Then there's this other part, which is, and we all do this as homeowners, we make decisions as we live in a home to go, I know that sprinkler is leaking, but you're not even thinking about it when you do the disclosure because it's so small to you. Only it turns out that sprinkler leak that wasn't really a big deal to you is actually causing a hillside stability issue for your neighbor, and you had no idea that this leaking was actually affecting it in that way, and then you get sued for something that you didn't really know about. So another good thing to know is the standard is that you actually knew about this, with one caveat. If you affirmatively disclose, everything is A-okay, and it's not, that can get you in trouble.
Right, so when you say affirmatively disclose, you mean there is no problem with the plumbing, or there is no problem with the roof. It's in great condition. That's considered an affirmative disclosure, that you're saying it's all good, there are no problems, and the buyer then relied on that to make their decision.
Correct.
Now, doesn't the buyer have a duty to investigate also? Because one of the things I tell my sellers when we're filling out the forms is, you need to answer this honestly. You have a duty to disclose. I'm always in favor of, if you have to ask me whether or not you should disclose something, just disclose it. Have the peace of mind that you have put it out there and you're making the buyer aware. So that's my personal philosophy. And at the same time, don't conjecture and guess about things. If you know, and just disclose it, and we'll move on. And when it comes to a buyer reading these disclosures, So back to the question, doesn't a buyer have a duty to investigate and do their diligence as opposed to just taking the seller's word for something?
Absolutely. And one of the things that's coming up quite a bit, especially in a hot market, has to do with sellers asking buyers to forego an inspection contingency in order to provide a competitive bid. And buyers, especially first-time buyers, don't really understand and appreciate the importance of that inspection, and they are willing to forego that process because they're getting outbid on so many properties.
Right.
And they're just desperate to get their foot in the door on the market. And it's a really big no-no. If you haven't done your homework, you can't cry sour grapes when you get the property and there were visible conditions that would have been apparent had you performed a reasonable inspection. So one of the other things that we need to really focus on is that the liability to the seller really arises from those conditions that would not be visibly identifiable upon reasonable inspection. So what do I mean by that? Well, you knew that there was a water leak behind this wall, you re-drywalled it without remediating inside the wall, covered it up, and no one would ever be able to see that there was actually fully saturated drywalling material and insulation material behind this, and that it was growing mold unless we opened it up. Meanwhile, you get people moving in and all of a sudden they're smelling something very weird and they open up the walls. That's the kind of condition that can really cause you problems, because you as a seller may have thought that you were repairing this and it may have been inadequately repaired. So one of the things, and there's no way for them to see inside the walls. So that's where your disclosure comes in, because you're disclosing that an event occurred and that you took care of it, and that I know you can't see inside the walls, but be warned, a condition did occur at this part of the property.
I'm so glad you brought that up, because one of the questions is, well, if there was a defect with the property and I repaired it, the defect is no longer, so do I have to disclose? And the answer that you so perfectly gave was yes. Even though there was a defect in the past and you remediated it and you corrected it, you do need to disclose the knowledge of that and what you did. And back to the point you made about record keeping, I was smiling when you were talking about keeping records and stuff, because I do have some of my seller clients who they give me a binder and they're like, here's everything we've done over the last 20 years. I'm like, oh, thank you, I love you. You're just so great, because I can just pass that along to the buyer. And say, here's what we did. But I would love to reinforce the practice of record keeping, because to the point that you made earlier, as a homeowner, you may think you've repaired it well or correctly, but maybe the person you hired didn't do the right job. What if you didn't keep the paperwork to actually be able to share with the buyer, hey, this was the issue, here is what we did, it is documented, here is the license number of the contractor who did the work. Or let's say you didn't hire a licensed contractor to do the work, you would need to disclose that as well. That's another line item on the disclosure, is any of the work that you've done to the home not done with the appropriate permits,
And I wanted to clarify something, because the technical standard may not be that you have to disclose a fully remediated condition. The problem for you as a seller is you have to ask yourself, well, do I really know that this was remediated, or am I relying on someone else for that information? And especially where a condition is no longer visible to you, my recommendation to clients is typically to disclose it, identify that the remediation was performed especially when we're talking about water losses, because one of the biggest areas of liability for sellers is mold that even the seller didn't know about. And it's pretty uncommon for a general inspector, unless there's visible mold growth, to identify mold conditions, because it is a microscopic process that isn't always visible to the naked eye. So when you are talking about what do I disclose, it's the material conditions that somebody wouldn't be able to see. And in my mind, that can include a significant loss that may have occurred, especially from water, because part of that condition may be hidden from the naked eye. That's a matter of good practice, not necessarily the standard. I think that that's the correct level of disclosure. But I think that the most important thing to keep in mind as a seller is it's just being sued for non-disclosure. That's really expensive. The California Real Property Purchase Agreement that is used by most realtors actually contains what's called a fee shifting provision in it, which means that there's attorney's fees for the prevailing party. This can make it very expensive for either the buyer or the seller in a lawsuit. And it's why the ounce of prevention is worth the pound of cure. You asked about inspections, and there's rules that say, hey, if you inspected this and it was available information to you on the inspection, then the buyer is basically precluded from coming back. But it doesn't stop you from being sued as a seller.
Right.
It doesn't stop you from having to incur the fees to defend yourself. And I actually find that most of the people who bring these actions on behalf of buyers, you get a buyer who's emphatic, I didn't know about any of this stuff when I bought the house. And then you come to find out they just had one general inspection. It was very cursorily done. They found the cheapest guy they could. They spent $250 on an inspection, and it wasn't really as thorough as it needed to be. And that gets into good agency work on behalf of your clients as a seller's agent.
Yeah, there is a lot more that goes into the investigations than just simply a home inspection. You know, that's just the one general physical part of it. You know, there are various kinds of physical inspections that can be done to the property besides the general inspection. There can be a sewer line inspection, a septic inspection, pool and spa inspection, electrical, plumbing, roof, geological if you have a hillside home. The list goes on and on and on. And so I think each property needs to be looked at very specifically when you are purchasing a home and making a really informed and thorough decision about, okay, what does this property require? What kind of diligence does it require? To the point of, just finding the cheapest home inspector who's gonna come, like, just give the home a cursory look and say, here's your inspection report. I think as a buyer and as an agent representing a buyer, you have to be a lot more responsible and diligent in that. Sometimes buyers, you know, especially given how competitive the market has been here in LA and how prices have been just going up and up, they're really concerned about, oh, this inspection is going to cost me $600. This one will cost me another $350. This one's going to cost me $400. It's going to cost $1,100 to get my geo out there. And everything just keeps adding up and up and up. So how do you justify spending all of that money? Well, to the point that you made, you know, the ounce of prevention is worth the pound of cure. You know, better to know about all of this up front than be surprised with it after you closed escrow, because you still have this, you have a window. I mean, as long as you haven't waived your investigation contingency, which we'll talk about in a minute, as long as you haven't waived that, you do have typically a time period, your contingency period, that allows you to do your investigations. And investigations go beyond just the physical property investigations, but also investigations about the neighborhood, the schools. Can you get insurance on the property, which is another hot topic that I'm going to reserve for for my insurance broker on another video.
And that you and I have many conversations about
Yes,
as well.
yes, as well. And permits, public records. I mean, there are so many different facets of the investigation, contingency that need to be looked at beyond just the physical piece
And
of
I
it.
think that you're speaking, people might assume you're speaking from the buyer's perspective alone on this. And that's actually not the case. Sellers, if your buyer is doing a shoddy job at investigation and you think, hey, that's his problem, not ours, just know and understand that if they're trying to save a penny there, they may be coming after you later with that. And I find that so many of the attorneys who are willing to take on those cases are hearing these pitiful cries, often from a first-time home buyer who barely scraped the money together to buy this starter home, and then are really shocked and surprised that there's $40,000 in deferred maintenance on the property. And the attorneys, I think, for the most part, are willing to go along with it and press play on a demand for mediation, which is required under the CAR form if you want to get attorney's fees. They're happy to go on and take that person's money and kind of fan their flames a little bit in terms of how angry they may be about the condition.
Right.
When in reality, an under-disclosure may not have even occurred. In fact, I had a client who I feel was sued for over-disclosing, which even that can become an issue.
How do you get sued for over-disclosing?
Well, you can mistakenly disclose when you're over-disclosing in a way that actually creates a misinformation about something. So, for example, one of the questions that's asked is, was all the work permitted
Right.
that was done on a property? And I have to tell you, sometimes whether or not a permit is closed, and I'm a real estate attorney, I deal with quite a bit of land use issues. And it can be really deceptive, especially for certain types of products that people are having installed, like energy efficient products in Los Angeles that may have 2 separate inspections before a final permit is issued for that. And you may have had someone come out and reasonably assume the permit was closed on that, but in reality the record controls. Now luckily in Los Angeles we're ahead of that. So in the escrow process, as you know, we as buyers would receive a 9A form that's going to tell us about the status of the open and closed permits on the property. But I think that a seller, when they're looking at answering that question, might want to be careful and talk to their agent about the work that was done. And if they're not 100% sure, hey guys, call up the contractor you use. Ask them for the closed permit for the work. Include that in your paperwork. People make a big mistake and they just start answering questions based off of their memory. Your memory is not accurate after
Right.
10 years of owning a home. These things weren't relevant or important to you at the time that they happened, and you may have just plain forgotten. So to the extent that you can spend a minute really looking into it and investigating it, you may save yourself a lot of heartache later and how to answer a question like that more accurately.
I think that's a really important point. I recently had a client who had made some repairs to their pool. Heavy-duty repairs. They hired a licensed contractor to do the work, but then they switched contractors in the middle of the job, and it was still a licensed person. And I was asking about one of the particular, repairs, just making sure it was permitted. And they said, "Oh yeah, the pool repairs were permitted." So I hop online to LADBS, and I'm doing my research, and I'm like, I don't see a permit for this work, and come to find out that everything had been filed except it wasn't finaled. So everything was done to code, but it was opened, but it wasn't final. So then that became a modification that we had to make to the transfer disclosure statement, which brings me to my next point. So Within the residential purchase agreement, the seller has a particular period of time which can be negotiated between the parties, but it's typically 7 days from the acceptance of the contract for the seller to make their disclosures and to present the completed disclosures to the buyer. Okay, so let's say the seller does that within their time frame, and the buyer has their time frame to review those disclosures and do their investigations. Let's say all is said and done, the buyer removes the contingency, and the seller then remembers, oh shoot, I forgot to disclose this new thing. I'm so sorry, it had completely slipped my mind, like it wasn't intentionally hidden from the buyer, it came out that they remembered, and now they need to make a modification to that transfer disclosure statement. So what some people don't realize is that once you change these disclosures, either the TDS or the SPQ, it can restart the clock. Maybe not the full investigation contingency period for the buyer, but the buyer, even though they removed their contingency, does now have 5 more days from the receipt of the updated disclosure to now evaluate what has now just been disclosed to them.
Sure, and I think that a lot of people mistakenly try to make certain repairs while the property is already under contract and then don't disclose those things because things may have come up during inspections and they're like, oh, I'm going to go ahead and repair that. All of those repair records and anything that happens during the escrow until you're handing the keys over to the other person, disclose all of it. I've seen situations, and I want to actually pay particular attention to HOA related issues because I do a lot of work with HOA governed communities, and I will want to really emphasize your escrow company should be pulling the HOA documents for the buyer. But if you know of certain things that the HOA has done regarding your property, make sure that you do not rely on those just being in the HOA documents. If you've been notified, for example, that you have a non-conforming architectural issue, I would go ahead and make sure to disclose that and just provide the notice that you've received from the HOA. For an example, everything is always kind of work it out with your agent on how to do it, but that's the kind of thing that I also see people get in trouble for, is that they were notified of something at some point and have simply either forgotten or thought it was resolved because there's a new HOA board. If you have something that you know to be non-conforming with your HOA requirements, your CC&Rs and bylaws, a setback, an architectural condition, unpermitted building, or structure, ADUs, we'll deal with that on a different topic.
That's another video.
But that is something that you should be, in most instances, disclosing to a buyer so that they don't get surprised if they get hit with some type of notice that has to be taken down when a new board gets elected, comes in and decides that is a non-conforming situation. So it's up to them to figure it out. If you don't know, you haven't been notified and you didn't refer to the bylaws, but it's still a good idea for you to make sure that as part of you tracking records, you're also tracking your HOA communications.
I think that is a really important point to make. Thank you so much for sharing that. I know sellers and escrows, what I do is I have my escrow company when I'm listing a home that is subject to an HOA. One of the first things I'll do is I'll let the escrow company know, hey, this home is subject to an HOA. Here's the HOA management company name. Here's the phone number. Here's the email. Here's the contact. So at least they can get on that, because it also can take a certain period of time to order those documents. And speaking of time, something you brought up earlier was a 9A report. A lot of people don't realize how much time a 9A report can take. It can take up to 10 business days to get a 9A report. And a 9A report is only applicable to the city of Los Angeles specifically. Not other cities don't have a 9A specifically. They may have their own city reports. But when you're dealing with a transaction, or when you're competing in a situation where time is of the essence and closing escrow or putting a deal together, when I take a listing, I let the seller know, hey, let's contact the escrow company now, even before we're under contract. Pay for the 9A report. It's like $73. Just give them your credit card, pay for it, let's order it, and let's have that ready to be part of your seller disclosure package. Because what we don't want to happen is for the 9A to get delayed. The buyer has already reviewed all of the other disclosures, have done their inspections, we're still waiting on the 9A, they removed their contingencies, and then all of a sudden we have a new disclosure,
As she's talking, Christina, I cannot help but think to myself, how many agents have no idea what you're saying right now? Agents!
That's scary.
And this is a point that I tell all of my clients, because I'll have a client say to me, I may have represented their family on other matters, and they're talking to me and they're like, hey, do you have an agent who you like to work with? And team, your guidance is only as good as the people you work with. Truly, unless you are an absolute pro house flipper and know all the ins and outs, you really should be relying on the advice of the people you work with. And most agents, I find, are so much more focused on sale and valuation that they really forget, omit, don't know to do this investigation, don't know how to guide their clients on it. People, do not use somebody just because she's your friend. Make sure that you find someone who has a tremendous amount of experience and a great track record as well on the transactions, especially within the community that you're buying in. The 9A form that Christina, that you were just talking about, is an LA specific form.
Right.
And they don't have it, for example, in Orange County. So in Orange County, you need to have an agent who knows, only in these jurisdictions do they use something comparable to that actually shows you, am I hooked up to sewer or not? Am I septic or sewer? Are my permits open or closed? Were they pulled or not? Those things are LA specific. Thank you, LADBS. You've done a great job with putting that online.
Yeah, absolutely.
And a lot of smaller cities have done a terrible job of that. And it means that you as a buyer may need to take extra steps. And it also means that you as a seller may need to take some extra steps to figure out what is the status of your permits. If you're not sure, don't guess on the seller property questionnaire and to transfer disclosure statement. It's the guessing or that sounds about right that gets people in trouble. When you make an affirmative representation, the buyer's entitled to rely on it. I want to talk about one other thing you brought up, which is, can you rely on your contractor?
Let's talk about that, because a lot of people do rely on their contractors. They're like, I've interviewed contractors, you're licensed, or so you say. How do you vet them? How do you make sure that they're really going to be doing the job that they're saying they're going to be doing? So I would love for you to talk about this right now.
California sets a really low bar for the dollar amount that's considered to be a handyman's type of repair that doesn't require a contractor versus when you're supposed to be using a licensed contractor. I have had the issue come up, whether or not it's valid. Again, this is also about not getting sued to the extent that you can avoid it, where people had repairs that were improperly done by unlicensed people, unpermitted work that should have been permitted that they didn't know about, or underdisclosed the scope of the work because there's not even paperwork that describes the work that was done. And very few homeowners are standing there and documenting and photographing or even know what they're looking at while a repair is being done to their home. They may check in and out, but you're not just standing there monitoring the whole thing, nor would you even know what you're looking at.
That's such an important point also. You could be there monitoring, have video cameras everywhere, but do you really know what's going on? Do you really know if the underlayment of the roof was done properly if you were to be seeing it done?
Right.
Or the, you know.
And so that's where using a licensed contractor, particularly in California, there are so many rules that favor and encourage the use of licensed contractors. There's a lot of good reasons for that. And one of them has to do with, then you're probably going to get the right, and not always, but probably going to get the right paperwork from your contractor to show the scope of work, what was identified as the issue, and what repairs and materials were used. I've seen situations come up on more than one occasion where I represented a client who either was making a claim about a completely improper repair that actually concealed a condition versus a proper repair. Now, if you have all licensed people come out and they did what they could for God and country to try to identify the source of the problem, the answer is, can you rely on that as a buyer? Sure. Doesn't mean you're not going to get sued if there's a problem that they didn't find. It just means that you have better paperwork about it to justify that your reliance on that was reasonable, and there is some case law that helps you out on that. What is going to be a problem is having used that handyman to do a licensed contractor's job. And you can get into a sticky situation, and you should think about it for a second. How would that look that, you had a water leak and you took out all the drywall, put in new drywall, and never tested it to make sure that the moisture was really fully remediated? You didn't even look to see if there was mold, and it turns out it was there, and you just had a handyman who can hang some drywall, do the repair. You might get in trouble for that at a later time. And it almost doesn't matter whether the law would hold you liable or not. The thing you need to know is you might get sued for something like that. So my recommendation to people is just to disclose what was done as best as they can by an unlicensed person and what their best understanding is of the scope. And you can always try to couch things in, whatever, qualifying language that you need. However, we're not experts, and buyers encouraged to get their own independent review of whether or not this is fully remediated.
Talking about buyers getting their own independent review, sometimes we'll see some sellers do a pre-listing inspection.
I'm so glad you brought that up.
Yeah, sometimes they do. I don't know your take on this. I'm really interested to hear what your take is. I normally don't recommend my sellers do a pre-listing inspection, just as a matter of practice. I don't discourage it. If they've recently had some work done and they're really like to, I don't say don't do it. But at the same time, I also tell them, look, this is not something that you have to do, but you do have a duty to disclose everything that you know. Sometimes when a seller has done a pre-listing inspection and it's been provided to the buyer, a buyer may say, well, hey, I already have an inspection report provided by the seller. Why don't I just rely on this inspection report? Why would I have to hire my own inspector to do essentially the same thing? And my answer to them, and I'd love to hear your take on this, my answer to the buyer is that home inspector was not hired by you to represent you and your best interest.
You buyer.
You, the
Correct.
buyer, yes. That home inspector was hired by the seller to represent the seller. And this isn't to say or to make any insinuations that home inspector was not doing a thorough job and just being very real about the inspection. But whoever you hire has a duty to you to do the best job that they possibly can in the most professional manner for you, their consumer. So I would love to hear your thoughts on pre-listing inspections and buyers' reliance on those.
Oh, goodness. Please don't get a pre-listing inspection.
Oh, okay. Oh, okay.
And,
all right. Okay, good.
And here's why I say that. So the standard is for the seller to disclose those conditions that they are aware of or have reason to be aware of that would materially affect the value of the property. When people hire an inspector, the inspector speaks or listens with a different accent depending on who is paying their bill, because what sellers are typically thinking of when they get a pre-listing inspection is, or an independent inspection is, I know they're going to come back, the buyer's going to ask for a lot of credits, and I want to get ahead of the game on that and be able to know this. Remember when we talked about over disclosures and that you can actually get yourself in trouble? What if your hired gun inspector on under-calling things actually gets you into a lot of trouble because they didn't accurately represent the true nature and extent of a problem that they may have seen in order to minimize it for sale purposes and marketing purposes, only to then create liability for you potentially on a back end. The other thing that it does, and it is an absolute buyer beware. This is not an inspection done for your benefit, and it doesn't check the due diligence box. Buyer's agents, you are not entitled to rely on the seller's own inspections with respect to calling it a day and saying, I did my job for my buyer client. That is an absolute no-no, and if I saw that, I would have a problem with the way that the agent handled that for the buyer. So buyers should always still get their own inspection. Now, that isn't to say that a seller's inspection doesn't make sense ever, and certainly work with your agent, but you need to be aware of when you want to be doing it, is because there is a condition that maybe the buyer and seller are arguing over for purposes of maybe a very large credit where it makes sense to bring in an independent person.
All right, so let's talk about exempt seller disclosures, okay? There are several instances where a home buyer is buying a property from a seller who does not occupy the home. It could be the home of a deceased person, and the person in charge of selling the home is the trustee of the family trust. Let's say the trustee has never lived in the home, they know nothing about it. Okay, now this is a very real and common scenario. Are different sellers held to different standards when it comes to making disclosures, especially in a case like this where they've never lived in the home?
Sure, it's a really great question. And the answer that all lawyers give in all of these instances is, well, it depends.
Sounds like a very lawyer answer, yes.
So the technical answer is that every seller still must disclose all known material conditions that are affecting the value of the property. But what you may know as someone who's never lived there is certainly signaled by this exempt seller form that's filled out, and it is done to signal to the buyer, a savvy buyer and a well-informed buyer, that additional inspections are probably warranted because the seller can't tell you about the contemporaneous condition of this property. They didn't do the repairs themselves, and they may not have access to those records. And let's talk a little bit about how this comes up, because almost everybody might be in a position, even if you're not a homeowner, where you're now having to sell a deceased parent's home or that aunt's home, and she really liked you and she named you as a trustee, and now all of a sudden you're selling an 84-year-old hoarder's home. You have no stinking idea what's been done to this house,
right,
what water leaks have happened. The appliances are all avocado green from 1974, and you literally just cannot say, that's fine, it's a form, it's a different form. And your agent, and a savvy agent, is going to help guide you through what that disclosure process is. Now, if you do happen to have personal information about it, and it can get into a dicey situation, and I've seen it before, where a kid is selling the property and the kid lived in the property when they were growing up, but they're,
right,
48 years old now, and they haven't lived there for over 25 years and have no idea what's happened. But their mom also told them, oh, I had this water leak and this and that. And I get into a situation where, as a lawyer, I'm not really sure what the right standard is for disclosure in that instance. So I think that if you have awareness of a condition that's occurred at the property and you're not 100% sure and clear that it doesn't need to, that whether or not to disclose it, I would disclose that you're aware something occurred. You can go ahead and say what was done to address it, and it would be up to the buyer then to determine whether or not the condition was remediated.
Yeah, I think that's definitely great advice. And you touched on the agent as well. In addition to a seller making their disclosures, the listing agent also has a duty to disclose. Not just the listing agent, but also when you're in escrow, the buyer's agent also has a duty to disclose. So let's touch on that. Both the listing agent and the buyer's agent have a form that they're required to fill out called the Agent Visual Inspection Disclosure. Okay, so as a buyer's agent, of course, you're not aware of the ins and outs of the property, so all you really have to rely on is your senses. Now, it's called the visual inspection disclosure, but it's also not limited to just what you can see with your eyes. It's also if you smell a particular odor, it could be musty, or it could, just be off. It could be something that you see or hear that could affect the value of the property. So whereas the buyer's agent may not know specifically from the seller about certain things that may be defects with a property, the buyer's agent has that duty to do their investigation. And that's the same investigation disclosure that the listing agent has to fill out. Now, the listing agent has had a lot more close contact with the seller. They're probably aware from conversations that they've had with the seller about this water leak or this crack here. But as a listing agent, I go through room by room inside the house. I make note of everything that I see, hear, smell, if anything is unusual. And it's not just limited to the inside of the home, but outside of the home as well. I walk the perimeter of the home. If it's something that I'm aware of in the community, for example, if the home is next to train tracks or a channel, those are things that you would end up disclosing. So even the agents have a duty to disclose what they know. And I think it's really important that as a listing agent and as a buyer's agent, you explain to your client why you are doing this. It's really just a matter of adding an extra layer of protection and transparency for everybody involved.
So let's go back to that, because I think it's a really important point. And a lot of the sellers I see over rely on the agent in terms of and buyers, they over rely on what the seller's agent must know because they're selling this property and they sell properties in this area all the time.
Right.
And I see this come up when you have a person who's a specialist in a certain region that may have a really unique issue to it, like it's prone to landslides, it's in a liquefaction zone, it's got a known chemical issue from a spill, or it's close to a power plant, things like that. You've touched on a few things that maybe you do need to disclose, maybe you don't. Train tracks are something that everybody can see here and are available to everybody to know. From the standpoint of me as a lawyer, I look at it more as a defensive ball document for just checking a box that you've actually seen the property and that this is what you're seeing on it. But I would not say that a buyer or a seller should be relying on either of the agents, either the buyer's agent or their own agent's disclosures in purchasing a property. And maybe you can share with me a little bit about what do you do in terms of helping the seller prepare their own disclosures in the case, because that's really what a buyer is entitled to more accurately rely on.
Right. I do get this question a lot from my seller clients as we're going through the forms together. They're like, Christina, how do I answer this? This happened, this is what I did. I may not be sure how to answer it. Do I disclose this? Do I not? Now, as a real estate broker, I am not allowed to fill out the transfer disclosure statement or the seller property questionnaire on behalf of my client. I can't give you the verbiage to use to make certain disclosures. But what I can do is to guide you through the process. And it's actually really simple what I tell my clients. I tell them a couple things. One, if you have to ask me whether or not you should disclose it, just go ahead and disclose it. Like, it's fine. You know, some clients say, well, what if I disclose this matter or that matter and then a buyer won't want to buy my property? You know, it's a valid concern, especially if it was some big ticket major issue that was wrong with the home. And what I tell my clients in those circumstances is, look, there is a buyer for everything. The reason why we are doing this process up front, we are doing our duty up front, is so that we can take everything into consideration in the marketing and positioning of your home as a product that is now to be sold. It is not just about the comps and where we price the home, where we go to market. It's not just about the nice photos and making the home look pretty and smell really good with the delicious smelling candles and, you know, did you have the housekeeper come clean it? We need to take these disclosures into consideration. And if we price properly, if we disclose and we set expectations properly, which is really key in anything that you're doing, it's going to be fine. There will be a buyer for your home, okay? So if you have to ask me whether or not to disclose, you should disclose. Do it to the best of your ability, because I need you to sleep at night calmly and sleep well and look at yourself in the morning when you wake up knowing that you have a clear conscience, that you've hired me for a reason, which is to help guide you and get your home sold and get the results that you want. So as long as you're doing your part and you're at peace with the process, truly, you know, mentally, emotionally, you're getting it all out there, you know that you're doing right by yourself and to the next homeowner, that's all you need to do.
And I've said this before, but it's really important that sellers understand it, not just buyers, especially like I said, those first-time newbie home buyers.
Right.
You're not selling a brand new home.
Unless you are, which is a completely different video
Which
topic.
is a different topic altogether. But
next video.
But in most instances, if you've lived in the home, you're not selling a brand new home. Something may have happened. Last year we had record rains in California.
Yes.
And one of the things that came up is people were calling me, telling me that this leaked and that leaked, and nobody had ever disclosed this to them before. And it's like, well, maybe it's because it never happened before, because
True.
we had an absolutely unprecedented water volume that was that we were asking not just our homes to endure, but our whole municipal water system, and nothing could handle that amount of discharge, and things happened that had never happened before, or systems that had been put in place like French drains failed because they weren't engineered to handle that amount of
Right.
water discharge. So sometimes things happen that really are unexpected, and just because you as a buyer of a home are experiencing something that maybe even seems significant doesn't mean that the seller even really knew about it beforehand. So everybody has to reset their expectations. Sometimes there really are these acts of nature. Sometimes there are things that are a process of the home aging, and you don't need to be ashamed of it. If you've done a great job in keeping up with this to the best of your financial ability as a seller, just go ahead and go back to your great record keeping, produce those records, and make your life really simple for both you and the buyer on the disclosures. And, you know, just a final point that I really want to make, and we keep coming back to this. The reliance on your agent for so much of the process is they are a really important part of what the seller needs to be looking to for guidance on these things, but potentially not on what to disclose. That is something that should come from the seller's own records and their own experience of living in the property. And as an attorney, I would really caution somebody, just as you've actually given great advice to your clients, and you've said, if you're having to ask me about it, you should go ahead and disclose it. If you're afraid that it's going to affect the value of the property, that is exactly what you need to be disclosing. That's the standard for what to disclose.
And additionally, to jump on that point, when they do have questions about the legal ramifications of making these kinds of disclosures or not, you're my phone call. The recommendation that I give them additionally, besides if you have to ask me, just go ahead and disclose to the best of your knowledge. If you're looking for legal advice, as your real estate broker, I'm your real estate broker. I'm not a licensed attorney. I cannot give you legal advice. So I do recommend on multiple occasions that my clients seek legal counsel specifically for this, just to make sure that they're protected.
I think that's such a great point. A lot of times people think that they've checked the box by having a really great agent, and that is definitely steps 1, 2, and 3 of how to make sure that you're handling your transaction well as a seller and as a buyer. But when stickier situations come up, especially when there are pretty significant known conditions that have occurred to a property. What if the house was involved in litigation previously? That may be something that it's just ounce of prevention, pound of cure. It makes sense to call a lawyer and run that by them, even though you're already paying your agent really well. That's not your job to know that.
Right. Final thoughts. I mean, this has just been so amazing. I'm really excited to get this video out in the hands of the public. So final thoughts for you. If you could give your top bits of advice to wrap this up from your perspective as a real estate litigator to sellers and their agents about disclosures, what would that be?
Electronically track everything. Every amount that you've spent, including on handyman work. Keep copies of your checks, keep copies of the receipts of appliances or other products that you buy and had installed in your home. Keep copies of all of the estimates that you've received for repair work and records to show that you've actually completed that work. And you hand a beautiful electronic file over to a buyer when you go to sell your house. It answers most of those questions. Your good record keeping along the way is one of the best things that you have as a seller to help you with making the appropriate disclosures. And I cannot emphasize this enough. Make sure that you're picking a great agent, not just with knowledge on how to price your home, not just the person who's going to fight for dollars for you on the sale, but the person who's going to understand that you need to be confident that when you sell this property, that's the end of the transaction between you and this buyer, so that you can sleep at night, as you mentioned.
Yes.
It is really important. You're giving someone a new home. Make sure that you're working with somebody who can help them understand exactly what they are buying.
I love it. Thank you so much.
Thank you so
You're just
much.
always a wealth of information. I love our collaborations together. You've been so wonderful in your help and guidance, both to me and to my clients. So I appreciate you deeply. I love you. Thank you.
Love you so much, and thank you so much, same.
Thank you. Thank you all so much for tuning in. This is going to be a topic that we could delve into so many more different offshoots about, but to just kind of recap what we talked about, take to heart what Michelle said. Document, document, document. It's all about the preparation and prevention as opposed to paying for the cure. And keep in mind that when you are choosing an agent or when you partner together with your agent to sell your property, you're becoming a team, okay? And the agent is supposed to build a team of great people around you to help you achieve your goals. It is not just limited to pricing and marketing. Part of my job for my clients, I feel truly, is to protect them and their best interests. As a real estate broker, I am my client's fiduciary. That oftentimes gets completely thrown out the window. People don't realize that I have a duty to do what is best for the client in all circumstances. And this disclosure issue, I feel, is so critical and fundamental to any seller's success. Again, it's not just pricing, it's not just marketing. Disclosures can open up a whole different can of worms when it comes to an escrow transaction. Deals can die over disclosure issues, and if they're not properly addressed, if they're not handled up front, if you don't look for the problems before they occur, you can't possibly prepare for them. So that's why this disclosure issue is so key. If you have any questions about disclosures or buying or selling property, please consider me and my team a resource. I appreciate you tuning in, and I really look forward to presenting more videos on topics of value to you, the buyers and sellers. Thank you so much.